Okay, we're going to try this again. This is Monday, April the 7th, 2014. I'd like to call the Tennessee Auctioneer Commission to order, and we're going to start over since we tried to start at 9 o'clock, but our agenda said 9:30, so this is a restart of that meeting. So if you would, please call the roll.
Bobby Colson.
Here.
Ronnie Collier.
Here.
Gary Cunningham. Jeff Morris.
Here.
Howard Phillips.
We have a quorum. If you would reread the notice of meeting.
This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website March 27, 2014. This meeting has also been noticed on tn.gov's website.
Okay, so that's the notice of meeting. If you would, take a look at the agenda. We've got 3 new items that are highlighted, and we need to readopt the agenda for today's meeting. So it's so moved.
Second.
Seconded. All in favor say aye. Aye. All right, the agenda has been reviewed and adopted. Under tab 1, you have the minutes from the February the 3rd meeting. We did not have a meeting in March of this year. You've had a chance to review those minutes, and we need to adopt those and put those into the record as well. Moved by Bobby.
Second.
Seconded by Ronnie. All in favor say aye. Aye. All right. Next on our agenda, we have the Sunshine Law presentation. If you guys would introduce yourselves and come up and tell us what we need to be sunshining about.
Right. Thank you all for having us here today. I'm Michael Driver. I'm Chief Counsel here with the Regulatory Boards Division, and we've been going around on a bit of a road show to the different boards and commissions around the department with a presentation about briefly on the Open Records Act and predominantly on the Open Meetings Act, the Sunshine Law. Damon Romano here is our law clerk. He's a 3rd year with the Belmont Law School and also a recent father, so we're glad to have him here with us. Without further ado, I'll turn the microphone over to Damon so he can do his presentation.
Thank you, sir. Commissioners, I apologize for the awkward angle, but thank you for having me. Excuse me, for the last week and a half, I've been running around with a hospital band, and I've had to tell people I did not escape. This is my ticket to get in to see my little girl who was a few weeks early, so they've got her in the NICU. All right. I'm going to try and talk to you all a little bit this morning about the Sunshine Law. When we talk about the Sunshine Law, we're talking about really 2 different laws, the Open Records Act and the Public Meetings Act. Excuse me. As Michael mentioned, I'm going to talk very briefly about the Open Records Act. As a matter of course, on a day-to-day basis, that's something that Director Whaley and her staff will take care of. Doesn't really touch you all on a day-to-day basis, but I'll give you the 30-second version so that we're all kind of up to speed. And let me back up for a half a step and say, I understand that this is not something that is new information for you gentlemen. As Michael mentioned, this is kind of a road show that we're going around to all the commissions and boards to try and make sure that everybody's on the same page, that any misconceptions that might have grown up over the last couple of years we can address, and that then going forward, everybody's on the same page and has a consistent idea of how we're taking these things. And there have been some developments in the law which have imposed then slightly different requirements on us on how we handle things. And again, so that we can all be on the same page there. So when I say the 30-second version of something, I understand that you all can squeeze a lot more information into 30 seconds than I can. So I appreciate your patience. All right, Open Records Act. What is included in the Open Records Act? When we talk about open records, we're really talking predominantly, not exclusively, about FOIA requests, Freedom of Information Act type of things. Anything you all do that has to be recorded that somebody might come back and ask for later. So then the question is, what's included what is subject to these requests that somebody might come back and ask for later. The law tells us it's all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files and output, films, sound recordings, and all other material. So they're getting everything. Excuse me. Now, that doesn't mean that when somebody asks that the request is necessarily going to be granted. It just means that pretty much anybody can ask for pretty much anything that you all produce on paper. And that's that. And by the way, given this forum, if there's just the 3 or 4 of us this morning, feel free to stop me and holler at me if you have questions. I'll do my best to answer them. Public Meetings Act then is going to be the crux of what we're talking about this morning. It's going to be what touches you all and your ability to do your job here on a day-to-day or month-to-month basis. Excuse me. We'll talk broadly about 4 things, what the Public Meetings Act is. We'll start with the law. By the way, as Mr. Driver mentioned, I am not a lawyer yet. I am a law student. I despise having soaked in it for 3 years. I hate legalese. And I have read enough law cases to just about turn myself blind. So I am not going to try and beat y'all over the head with that. There are 2 or 3 cases, though, that are kind of important, and I'll touch on those as we get to them. But we will cover a little bit of the law, what the Public Meetings Act is, what is a meeting and what's not. Once we figure out what a meeting is, we'll look at what is required of you all. More specifically then, that's going to be broadly 4 things: notice, agenda, public presence, you have to let people come and observe, and minutes. We will discover as we go on that once we figure out what a meeting is and once we figure out what notice is, we will have covered about 90 or 95% of everything that you all are responsible for. If you violate the act, either as a whole commission or as an individual commissioner, what's the penalty? It's nullity. Just means we're going to pretend as though it never happened. And we'll see as we go on that that can have some consequences and ramifications flowing downhill. All right. Public Meetings Act. General Assembly hereby declares it to be the policy of the state that the formation of public policy and decisions is public business and shall not be conducted in secret. Public policy is generally going to be your rules and regulations, adopting new ones, amending existing ones, deleting old ones. Public business, pretty much everything else you do. Issuing licenses, discipline against licenses, revocations, adoption of minutes and agendas and all of that stuff. Any kind of continuing education, if you have any of that, all of that is going to be in the decisions part. This is simply the free speech clause of the Tennessee State Constitution. And the reason it's in here is to say, look, we understand that you all have volunteered to do a service, a public service, and that your volunteering or your agreeing to be appointed to do this public service does not infringe on your rights as a citizen of the great state of Tennessee to have free speech, to speak your mind. The way to read those together then is to say, look, we're not telling you what you can and cannot say, but when you are acting in your capacity as a commissioner here, everything that you say needs to be on the record under the gavel in a properly noticed meeting. The act is remedial in nature. It's a fancy way of saying we can't fix a problem until it comes up. Excuse me. And because we can't fix it until after it's come up, we're going to construe these laws as broadly as possible to protect the public. And every time, this is the first time we'll see this, and we'll see it several more times, every single time without fail that there's a court case on this, every single time the state legislature goes digging into it to amend it or update it, every single time they will always use this very broad, very expansive, very inclusive language. They're trying to get everything in there and leave no loopholes at all. And again, we see this very expansive language. All meetings of any government body are declared to be public meetings, open to the public at all times, except as provided by the Constitution of Tennessee. That except is a very narrow exception. It's called the executive session, and we'll talk about that in more detail in a few minutes. Absolutely applies to this commission. The law there states governing body. It applies to governing bodies. We've seen that already. A governing body means the members of any public body, which has 2 or more members with the authority to make decisions to a public body on policy or administration. So we see there that the legislature intended to include any commission, committee, agency, authority, any other body by whatever other name. Again, that very broad language. It's all inclusive. Every meeting is covered. So this is your regular meetings such as today. If you have any special meetings, they're also picked up. I don't know if you all have ever had any emergency meetings. Some commissions find that they need to, and those commissions will find that even their emergency meetings have to be scheduled out 2 or 3 weeks in advance. Why? Well, so they can provide enough time for adequate public notice, because even those emergency meetings are picked up under the Sunshine Law, and you have to have the public know what's going on there. We'll see here this language in that second line to the bottom: decision, deliberate towards a decision. Your sort of 3 Ds: decide, deliberate, and debate. Those are the 3 things that we want to make sure that we're never doing behind closed doors. There's a 4th D, discuss. That's kind of a fine line, provides a little bit of weirdness, and we'll talk about that in a minute. Again, we're picking up our committee and subcommittee meetings. I had one commission in particular say to me, well, as long as we do our full board meetings on the record, we can do our committee and subcommittee meetings behind closed doors, right, and actually get work done. No. All right, let's see if we can try to put some fences on this and put some bounds around it and establish some boundaries. A meeting does not include any on-site inspection of any project or program. May not apply too much to what y'all do, but we can see how that would get unwieldy real quick. Some of the boards and commissions have staff members that routinely go out and conduct job site inspections, things like that. Well, if that becomes a meeting under the Sunshine Law, that's going to bog down the process really quickly. This is sort of the into the weeds discussion, and this is what most of the boards and commissions before which I speak are most concerned. A meeting is not a chance meeting of 2 or more members of the public body. So if you, Chairman Morris, run into Commissioner Colson in the Piggly Wiggly and happen to bump into each other, we're not going to say that that is suddenly now a meeting of the Auctioneers Commission, okay? However, no such informal assemblages can be used to decide or deliberate public business. This is the spirit of the law clause or requirement. I've cited that case down there, Aiken versus the town of Kingston Springs. Excuse me, and that's the first of the cases that I want to talk to you about real briefly. In Aiken, what you had was the town of Kingston Springs goes to try and annex some of the unincorporated county land surrounding. And eventually, they took the up or down vote, yes or no, we're going to annex or we're not, in a full town council meeting with everybody present. It was on the record, it was under the gavel, it was properly noticed, and everything was fine. However, before that, when they were deciding exactly which plots of land they were going to annex, they did that behind closed doors. And somebody got upset about it because they suddenly found themselves annexed and they didn't know that they were in that plot to be annexed, and so they sued, and that's what generated all of this. You'll notice there at the end of that first line of small print, it's the Tennessee Court of Appeals, which means that by the time they got through with this process, they had done that dance 2 or 3 times. Okay. Now, eventually in that case, the town of Kingston Springs won. They successfully defended their action, and the Tennessee Court of Appeals finally came down and said, look, while they circumvented or contravened the spirit of the law, we can't find a letter of the law violation of the Sunshine Laws. And so the legislature comes back in afterwards and says, can't use informal assemblages to circumvent the spirit of the law. So we've covered that now. But what I would like to suggest to you at this point is that even if there's a violation or a potential violation, even if you eventually win, well, I would like to suggest to you, gentlemen, that if you get sued, you've already lost. The black hole of time, budget, staff time and effort that gets sunken into one of these things is just disastrous for you as a commission. And so we want to share a meal together in which public business is conducted, but such discussion, 3 things you want to avoid. And I would like to point out at this time, I don't know that I can say what the difference is between discussion and deliberations. And if you gentlemen think that you can accurately predict what some judge is going to say several months from now, whether it was just a discussion or whether it was deliberations in violation of the law, you're smarter than I am. And so that provides us with kind of a fine line that a lot of people haven't been able to figure out. So we want to, again, kind of step back from the edge there. What's not a meeting? Any kind of lunch breaks, restroom breaks, smoke breaks, any recesses between sessions. If you have a multi-day meeting and you adjourn at 4:30 or 5 o'clock one day and come back the next morning, all of that time in between overnight, that is not a meeting. But of course, then that means that those are times when commission business ought not to be conducted. I mentioned before, regular meetings, special meetings, emergency meetings, they're all subject to the law. Our only exception there is that executive session. So let's talk about that. 3 requirements. When one or more of you, and it can just be one of you, when one or more of you meets with your board counsel, Ms. Kropp, and you're under a lawsuit or somebody's threatened you with a lawsuit, and you ask your attorney questions related to that suit. The point of this executive session exception is to provide you all with an opportunity to go behind closed doors and get Ms. Kropp's sound legal counsel about some action that you've done or are contemplating doing or related to some lawsuit. You know, if somebody catches you in the hallway, you take a recess and they say, Mr. Chairman, I don't like how you all have done that piece of business. I'm going to sue you. Well, that's a good opportunity then to go into that executive session, get behind those closed doors with Ms. Kropp and say, we've been threatened with a lawsuit over XYZ issue. Please give us your advice. Now, if you then say, well, okay, now we've gotten her advice, and based on her advice, I think we ought to do this. No. Now we're getting into that debate, that deliberation. That's when we need to step back, get back in the committee room, the commission room, get back on the record, and go forward from there. We think you might be getting the impression that this is awfully invasive, awfully intrusive, and it's beginning to step on my ability to do my job. And you might be right. So let me give you an idea of how far it actually goes. In Maury County, there's a civil service commission, and they were conducting first-level interviews of people, excuse me. And when all the interviews were done, the civil service commission met behind closed doors to discuss the interviews that they had just given. And then from that meeting, they boiled down all the people that they had interviewed to a vetted list of qualified candidates, and that list then was sent over to the sheriff's department in Maury County, and they would hire deputies and other staff from there. And here you've got the Attorney General saying even that meeting about the results of job interviews probably is subject to the Open Meetings Act and probably needs to be noticed for the public and on the record. Well, you think, gosh, it's job interviews. Can't I do my job and just talk about these job interviews without getting caught up in this? As it turns out, you can't, because what the court is going to say there is, look, these decisions have potentially huge impact on the public, and so the public has a right to know about them and know what's going on. Let me move to, if I may, electronic communications real quick. If one of you emails your chairman and says, here's a news article related to our profession, and I think it's something that we need to talk about, that's fine. If you say something like, you know, such and such an issue has come up, and I think it's vital that we have it included on the next agenda, that's fine. But if you say, well, here's a news article where, you know, one of our licensees has been arrested, and we need to consider disciplining against that person's license, now again you're into that deliberation, that debate, and that's not going to work if it's that kind of crosstalk off the record between the two of you. Email or fax or telephone or any kind of you know, off-the-record communication with Ms. Kropp, your board counsel. If you say, I have a question about the legal consequences of something we've done, that's fine. If you say, I've taken an action as a commissioner and now somebody's upset, if you go to talk to a trade group or a high school or some charitable organization representing the commission without having gotten the commission's approval to speak on their behalf, that's not something she can help you with. She can give you her legal counsel as an individual commissioner acting in your individual commissioner's capacity. But it's not going to help you too much to call her and say, I've been picked up for my 19th DUI in 25 days. That you need to get your own lawyer for that. This is where we get into a real problematic kind of an area. If one of you takes to email or to call on the telephone another one of you, the court's going to say that is not that accidental meeting or that chance meeting or that informal assemblage that we talked about earlier. You don't get the Piggly Wiggly exception for that, because they're going to say, look, if one of you takes the effort, takes that deliberate action to pick up the phone or to write that email, that's not a chance meeting. You did it on purpose. And so you're not going to be protected there. Excuse me. And this is sort of going to the heart of my presentation this morning. If one of you calls up the other one and says, you know, I understand your part of the world was hit by that horrible ice storm we had about a month ago. Is there anything I can do for you? We've been friends for a long time. Or I saw your little girl in the school play the other week. Gosh, wasn't she cute? Is the content of that kind of a communication perfectly innocent and above board? Sure it is. But that's not what folks are going to see first. The first thing they're going to see is that you've got this off-the-record kind of crosstalk between a couple of publicly appointed commissioners, and it's going to raise a lot of red flags, and it gives that strong appearance of impropriety, and that's why I say there, for safety's sake, all that kind of off-the-record crosstalk ought to be avoided whenever absolutely possible. Briefly, we'll talk about electronic attendance. Excuse me. Y'all already know, I'm sure, that if one of you is not here physically present, you can be telephoned in and be heard over the PA. The only requirement there then is that every vote has to be a roll call vote. You can't do the all in favor say aye, all opposed nay thing. Why? Again, the public has a right to know who's voting how. And if y'all are here present in the room, they can see. But if one or two is not present, are not present, then we go to that roll call vote so that the public can know what's going on. If you can make a quorum just like today with those that are present in person, that's fine, you just move forward. Let's say there's only two of you here though. Could you still go forward with the meeting? If you adopt that, what's called a statement of necessity, and I don't know if you've ever done that before, Chairman Morris, but let's say it was just you and Commissioner Collier here this morning. If the only way that you could get to a quorum would be to phone somebody in, you can do that. You just need to then get on the record some statement that says, look, we understand that by the rules, we're not supposed to proceed without a quorum physically present. However, we also have this mandate from the public, from the governor that appointed us or whomever, to do this business, to do the work that the state requires, and so we have a need, we have a necessity. And so I'm making this statement of necessity on the record that despite these less than perfect circumstances, we are required to move. I feel a need to move forward with this meeting. We're adopting that statement of necessity. We're going to phone in our third or fourth member, and once you've made that statement, you can proceed as normal. Again, here we see the act is to be construed most favorably to the public, is all-encompassing, applies to every meeting of a governing body, and that except there is a whole bunch of complication. It doesn't apply. Excuse me. This is the second case that I wanted to touch on. It's sort of a sad story, the Shelby County Commission case. What you had was the Shelby County Commission. There was a long-serving gentleman who was widely respected according to the record in the court case that I found, and he died in office. And he represented a strongly minority section of the county. And so what you had was 3 other commissioners started talking to each other over the telephone and saying, it is important, it's ethically important, it's morally important that we make sure that when we replace this person, because they had to appoint to fill out the remainder of that gentleman's term, it's important that we get somebody from that same section of town to adequately and accurately represent those folks. And so they came up with a short list amongst themselves, and then they narrowed it down to 1 or 2, and they called this one gentleman, and they said, if you were nominated, would you serve? And he said, yes, I'd be honored. And so at the next full meeting of the Shelby County Commission, they were all there, except the one empty seat. The chairman calls the meeting to order, notes the vacancy, notes that the gentleman had died in office, expresses his condolences to the gentleman's family, and says, we need to make an appointment to fill the remainder of his term. Are there any nominations? One name was mentioned. Is there any debate? There was no debate. All in favor say aye. Aye, unanimously. The gentleman happened to be in the audience. He comes up, he's sworn in, he takes his seat, and he begins to serve. And somebody says, well, now wait a minute, that looks awfully fishy. That doesn't pass the smell test. There was one nominee, there was no debate, it was a unanimous vote. Something's not right. And so they sued. And you know how court works. It takes several months for it to come up at trial. Eventually, the court here, and again you'll notice it's the Tennessee Court of Appeals, and so they, again, we'll see that they went through that whole dance 2 or 3 different times. But eventually the court comes down and says that is a textbook violation of the Sunshine Law. It doesn't get any more obvious than that. And so they struck it. Remember at the beginning I said the penalty for violating the Sunshine Law is nullity, as though it never happened. And so what they did in that Shelby County case was they rewound the clock to the moment that that gentleman had been appointed to fill the vacant seat, and they said it was as though he had never been appointed. And so any vote in that intervening time where he was the deciding vote, gone. Any committee that he chaired or subcommittee that he chaired, gone. And so what you had was somewhere around, and I confess I've had a little trouble with the timeline, but somewhere in the neighborhood of 8 or 10 months or a year's worth of business. Gentlemen, Shelby County is not a small outfit. It's not a small place. All of that work of the commission was evaporated, or if it wasn't, it was strongly called into question. And suddenly now there's this huge shadow or cloud that's cast over all the business they did. Not to mention the extraordinary cost, that black hole I was talking about in terms of staff time. All those commissioners needed to be subpoenaed, go give testimony, give depositions, and so on and so on. And so that massive sinkhole of time going forward during the lawsuit, backwards during all those decisions that were voided or nullified, it was a mess. And again, I'll go back to the idea that I mentioned at the beginning, that if you get sued, you've already lost. And so we want to avoid that if at all possible. And so we can see that even with the best of intentions, a violation of this law, even by accident, can have really gross and disastrous consequences. All right. So that was awfully heavy. Let me throw you a bone and lighten up a little bit. Public attendance. As you already know, the public has a right to attend the meetings. That's the whole point of what we're doing here today, and that's the whole point of these sunshine laws. However, you're not required to let them speak. They have the right to observe, attend, see what's going on, but you have an agenda that you need to stick to. You have a certain list of business that you all need to accomplish in any given meeting, and the courts and the legislature are sensitive to that. They want you to get your work done, and they don't want you to be derailed by somebody coming up and talking nonsense. Now, you may decide that you want to allow the public to speak, your licensees. You may decide that, this decision that we're deliberating or debating is something that we want to get feedback from the auctioneer community about, and so we're going to let them speak. But you're perfectly within your rights to say, look, we've only got 30 minutes for public comment because we've got an agenda we need to stick to, and I'm only going to give you 60 seconds each. As long as you treat everybody the same, treat everybody fairly, that's fine. Excuse me. All right. I mentioned before that once we figure out what the meetings are and what they're not, and what's required of you under the meetings, once we figure out the meetings and the notice, that's about 90 or 95% of it. So let's run through notice here real quick. 3 things for adequate public notice: the timing, the contents, and the location. Here, contents have to reasonably describe the purpose of the meeting and the action to be taken. By the way, the key there is reasonably described. I've been before 1 or 2 boards where they think that if they deviate the slightest iota from the published printed agenda, that they've violated the sunshine law. No, that's not the case. It is not Charlton Heston standing on top of the paper mache mountain with your agenda, and it's carved in stone, and it shall never change. No, we know, we can see that at the bottom of every agenda, there's a line item that says new business. Well, nobody knows what that is going in, and so that gives us an idea that we're not chained to it, but we do have to reasonably adhere to it. Excuse me. And again, the idea there is so that a member of the public can come in, and if there's an issue about which a member of the public or a particular licensee is especially interested in, that they can see the published agenda and know that if they show up that day, that thing that they care about is going to be talked about sometime that day or sometime in that meeting. Has to be posted sufficiently ahead of time. If you publish the world's greatest notice 20 minutes ahead of the meeting, it's not going to get you very far. The rule of thumb, by the way, is 7 to 10 days. Usually the courts are going to say if you published a notice 7 to 10 days ahead of the actual meeting, then you'll be covered. As a matter of fact, you know that your notices are published months ahead of time. The agenda, I think, for this meeting was, would you say, Kim, it was up in August?
No, the date.
The date was up in August.
The date and time.
And if you were to go on your website right now, you'd see all of your meetings, I think, for the remainder of the year. So you're covered there. And again, that's this notice thing is as with the public records law, it's largely, as far as you're concerned, a matter for Director Whaley and her staff. But I just wanted to give you an overview of it so that if you have any questions, you know where to go seek answers. If you give the world's best notice and you publish it a year ahead of time, and the only place you publish it is in the basement next to the boiler room, it's not going to do you much good because then nobody can see the notice. Usually, we publish on the internet. That is the widest possible circulation. So you'll find that the notice of this meeting and today's agenda are published on the big Department of Commerce and Insurance website and on your commission's website. And as y'all were talking about beforehand, there's that text alert system to where a member of the public can sign up for that and then get that text message or that email blast when the thing that they care about is coming up. As we say. And this is just a clarification of the other from the Tennessee Attorney General. We can use newspapers, we just don't. We can use bill postings, stapling up flyers, and we do kind of do that. It's not formally part of the notice, but you may see as you walk in the building, there's a flyer stapled up in the lobby that said, hey, the meeting is on this floor in this room. Bless you. So as we wind up then, excuse me, we talked about the legal effect is nullity, as though it never happened for a violation of the Sunshine Law. There is a practical impact that will almost certainly involve substantial costs. If you get sued, it's that massive sinkhole in terms of staff time and energy, which is time and energy that they can't be working on the important business to which you have set them. Excuse me. And it's also your time in terms of driving up here to get subpoenaed, to get deposed, to give testimony, so on and so forth. In a nutshell then, it absolutely applies to the Auctioneers Commission. It applies to you both as a commission and as an individual commissioner. If there is more than one of you, and this is our sort of rule of thumb as we wrap up, if there is more than one of you staring into a mirror discussing commission business, it's probably a meeting. And it needs to be properly noticed and under the gavel and on the record. Of course, if there is only one of you discussing commission business in the mirror by yourself, you may have other problems, but it's not a violation of the Sunshine Law. The only exception, again, is that executive session, that opportunity for you to go behind closed doors with Ms. Kropp, your board counsel, get her sound legal advice. But again, that's just going to be a legal advice session. We can't use that as an opportunity to debate or deliberate or decide any business that is before you or potentially before you. And by the way, if you start into that in an executive session, it's part of her job to stop you and say, y'all can't deliberate or debate in here. Get back under the gavel to do that. For every meeting, you have to give adequate public notice in terms of the content of the notice, where it's posted, and how far ahead of time you post it. If you violate the law, those acts are void. I say there at the bottom, be paranoid, and I should probably change that. You know, if you truly are paranoid, you're going to be paralyzed and not able to do your job for fear of, you know, getting sued or getting called on the carpet for it. And that's not my intention. My intention is not to come before you gentlemen today and waggle my finger or put the fear of God into you and make you want to go into your rooms and never come out. My intention, though, is to say that we want to be, this stuff is out there. And so as you decide how to proceed, how to govern yourselves, what is going to be the topic of discussion in the men's room or at lunch, know that this stuff is out there and that it is not speculative. So maybe I should replace it with be scrupulously aware of what's going on. Are there any questions? That's the conclusion of the formal presentation.
No, I think you covered it quite well.
All right. Gentlemen, thank you for your time this morning. I appreciate you. Julie, thank you. If you need us for anything else, or if you'd like a copy of the presentation, I'll get it to Director Whaley and she can get it for you.
Well, we appreciate that, Damon, very much. And I think we're now acutely aware of what our responsibilities are. Next on our agenda, sticking to our agenda, we have Wendell Hanson going to give us an education provider update.
Mr. Hanson, I would ask that you step to the podium so that you'll be on record.
That'd be great.
Thank you, sir.
Thank you, gentlemen.
Good morning, Commission and staff. This is the Auction Commission report for education provider. The newsletters have mailed. They've gone out for this quarter. Our next CE seminars on May the 19th at Montgomery Bell State Park at 9 a.m. Billy Trout from the Department of Revenue will be the speaker on sales tax, and Justin Oakes on voice care and psychology of the sale. I would ask that if you have any suggestions for the newsletter that you email them to me or just tell me, and because we're garnering any suggestions that you might have for upcoming newsletters, and also for 2015 seminars. We're planning those right now too. So thank you.
Thank you, Wendell. We appreciate that very much. Julie, are you ready to do with the
Certainly, Leanne?
legal report.
A tab on your iPads, and I just have one matter this month. We're doing really good keeping up with our cases. I think at the last meeting in February, we had 8 or 9 matters, so right now, there's just one on deck for us to hear. There's a couple more coming down the pipe, but I don't have those yet, so this shouldn't take very long. The matter on the legal report starts with 2014000331. Complainant was the purchaser of a tract of land, which was one of multiple land tracts sold at an auction held in 2010 by respondent, which is a firm. Complainant states that the tracts were to be used for agricultural use only pursuant to a declaration of restrictions, and complainant states that respondent represented the property with the wrong zoning, which caused problems for the owners of several tracts getting building permits. Complainant attached documentation, including the filed declaration of restrictions regarding the tract of property which was developed into multiple tracts, and which states, in pertinent part, all tracts shall be used exclusively for single-family residential and agricultural purpose only. Further, complainant states that at auction it was stated that the sellers were paying for a power line to be extended to the tracts, and complainant questions whether respondent should have escrowed this money to the title company, as complainant experienced difficulty in collecting the utility money. A response was submitted on behalf of respondent pointing out that the restrictions state that the tract shall be used exclusively for single-family residential and agricultural purposes only. Further, respondent states that extension of power was paid by the sellers, and respondent did not collect any funds for the power extension, nor was it represented that respondent would collect the funds for power. Also, respondent attached a copy of the real estate sales agreement with complainant, in which respondent points to language stating that the property is subject to all instruments of record, including zoning, and the property is sold as is and where is. Respondent denies the allegations against it. Based on the documentation within the file, there does not appear to be a violation by respondent. Therefore, the recommendation is to dismiss.
Trouble figuring out what
Complaining about.
they're complaining about, and where was he harmed or damaged?
Well, I outlined it as best as I could based on what the allegations were and what the documentation was submitted. That's why I included what the deed of restriction stated, because I did have a copy of the filed document. I don't see that there were any issues here. I don't know if there was a misunderstanding. The fact that it took place in 2010, I'm not sure, but I do have the sales contract and from all the...
It took place in 2010 and they're just not complaining?
Yes, sir. I believe the sale took place in 2010. Yes, sir.
And they're just not complaining?
The complaint was just submitted at the end of 2013 and processed. That's the timeline that I have.
What date was the complaint filed?
It was received in the office, it looks like on January 10th of 2014.
January of this year,
Yes, sir, and it
for an
says,
auction that took place in 2010.
according to the complainant, it took place in June of 2010. It appears that the reason for the complaint is the misery and expense encountered by the new owners dealing with extending power lines, and
Seller did pay for that, right?
that's what says, that's what the respondent says. Now, the complainant says with the help of other tract owners, the complainant personally collected the utility money.
This sounds like a civil case rather than
Right, I don't
a
see
complaint
any
against a
evidence.
licensee. I mean, there was no,
I don't see any evidence of any kind of misrepresentation in the documentation that was provided. Of course, you know, I didn't have the benefit of being at the sale. I'm not sure what was said there, but based on the contract, which I do have, in the declaration of restrictions, I just don't see any misrepresentation. I included almost all of the information that was in there because it wasn't a very lengthy complaint or a ton of documentation, so you pretty much...
I'll go with legal.
moved in second that we accept the legal representative's recommendation for this case. And all in favor say aye. Aye. Motion passes. Dismissed.
If you don't mind, I'll just give you a quick update on our rules there with the Attorney General's office right now for pre-review as to constitutionality. After that, the Governor's office will take a pre-look at them, and then we will schedule the public hearing regarding the notice of rulemaking. So those are progressing down the line. So
You want to go over through your administrative report?
Sir.
You kind of get through that.
Yes, sir. On tab 3, you have complaint comparison information.
Pretty much the same.
Yes, sir. Quite well against the for closing, for legal action, all cases within the 180 days, 97% of the time. So, very strong.
Right, and then our budget report.
Yes, sir. On tab 4, you will find information related to the revenues and expenses of the commission, and additionally, you have information on the Auctioneer Education and Recovery Fund.
Thing that you want to bring up of notice?
No, sir, there is nothing specifically to draw your attention to.
Progressing is good.
Yes, sir. Okay.
Next item.
Yes, sir. Tab 5 is an application for a public automobile auction, and it is presented for the commission's review. And
All of these have to be approved by us individually. Is that the case?
Yes, sir. I believe there are 3 separate types of applications that would need to be reviewed and considered by the commission. I think there are 3 completely different types of applications.
Public automobile auction is one that we do have to approve at a commission meeting, I assume. And this application, would you say is fully 100% complete in terms of having all the minimum requirements?
yes, sir. The first page of it is a checklist that the office uses, and it shows that they have met all of the requirements.
Keeper liability, surety bond, compiled financial statement worth of 100. Proof of motor vehicle dealer. This is down in Chattanooga, I assume.
Yes, sir. They indicated the address would be in China.
Principal auctioneer is Austin Nightgrass. Affiliating with Reliant Realty Auction Division? Or
Auctioneer. That's the auctioneer's firm.
owner of the business is Mary Ann Andrews, and the auctioneer is Austin Nightgrass. Is he not an owner?
See, I thought they were supposed to be.
See a reference in the rule of the statute. Has to be
Company called Dealers Auto Auction of Chattanooga. LLC. Mary Ann Andrews. That's Austin Nutgrass. That's Austin Nightgrass. Business name. Like Mary Ann's gonna own the business, and Austin's gonna be the principal auctioneer.
Who's
dealer license.
Auto auction of,
Yeah, do LLC does.
There's a copy of that on the page.
If this is any relation to that outfit out of Memphis.
The mailing in Memphis.
There's a mailing address in there?
According to the second page of the first page of the application, the second page, that's the mailing address.
P.O. box.
It's a
in the-
P.O. box, but
Yeah. There's a guy by the name of David Andrews that has a big company down there called City Auction. City Auto, excuse me. They're a big website, car dealer. Any reason why we should turn it down? If they've met all the requirements.
Austin. Representative Willie.
Licensed 2000. Oh,
30-hour course.
I don't think his is new, but that's in the file.
paperwork.
Is that one of the requirements, though?
It looks like he already has his public automobile.
Since 2009. Are you asking if the auction itself?
Oh, the auctioneer.
Auctioneer.
Right, he's been a auto auctioneer since 2009. I would assume certainly go back in his records and look back. I mean, for him to have the licensure.
No.
No. He's got to have a,
Total different thing.
it's, yeah. It's,
Any auctioneer, he may have been selling cars at an auto auction somewhere, but you still have to have the public automobile auction license.
school part, the educational part of
Right,
it, the
and that-
30-hour course.
Right, to have the public automobile auctioneer license. Right, and that's, that I believe, the notes here indicate that he's had that designation since 2009. You can certainly defer, and we
What's
can
it,
go
what's
back.
it called? Yeah, public automobile auctioneer license. And to get that, you had to went through school. Gotta have that.
He can't just have a regular auctioneer's license.
Right, I think he's got both, because you'll see it says number 28, and below that 5422. So I believe he already has both licenses according to
What's
this.
that number 20?
Yes, sir, I believe it is. And we could double check that on, do we have RBS on that computer over there? No.
I can look online and see.
We can double check that to be sure that that's the number, if that's what you're asking. But I believe, according to this, that's how I read it.
That certificate should have been in this packet.
You need to add it to your checklist.
Yes, sir.
Of the number one on the checklist.
Right. Public automobile auction app. Could have that school.
In order to get his public automobile auctioneer
Right.
license. And so that's probably within his licensing file, I would guess, but we can verify that licensure on the website right here.
Issuance date 10/7/2009. Do we have it down in 2009?
That may be his auctioneer license, but
No, I'm talking about the auto auction law. Wasn't even passed then, was it? Yeah.
It says 08.
And what year was that, Bobby?
Several there that I didn't know.
What year was that, Bobby?
I can't remember.
2009?
The effective date
Been
was
5 years
January
ago?
1st, 2009, according, in the statute book, that's the effective date.
What was it?
January 1st, 2009 is the effective date of the
Okay.
statute.
Okay. That all ties together then.
Purposes of enacting rules, it was in April 10th, 2008, which appears to be when the rule was,
I don't know how, can we pass this contingent upon double checking that 30-hour course, or do we have to wait to have confirmation on that?
I have him listed as license number 28, original licensure date 2009. Rank is public auto.
Okay,
Certainly can,
all right.
I will, you can pass it contingent and we can double check.
No, I
his-
mean, I don't wanna hold it up, but I'm just, you know, because
You got it,
if,
the state stuff.
Says that he is a public auto auctioneer.
assuming that that's true, then,
Might get him to send in a copy of the certificate, just to have it in the file.
License is still valid. It is October of,
other debate? Or discussion, or deliberation? Hear a motion?
Approve.
Move to approve the application. Is there a second? Ronnie seconds. Any other discussion? All in favor say aye. Aye. Motion passes. All right. You got, continuing education course provider application on tab 6 and tab 7.
yes, sir. This is a 6-hour online continuing education course presented for the owner and instructor has been licensed as an auctioneer in the state of Georgia for 4 years and 6 months. He also has a bachelor's degree of science in electrical engineering.
Auction school.
Course title is Auctioneering in the 21st Century. There's a description. Online auctioneer continued education course focuses on internet marketing and website optimization, as well as auction contracts and laws in Tennessee. There's information.
I have some additional,
I was gonna say, it says there's some things attached
yes,
here.
I
but-
have, we did not put the entire packet on your iPads, but I do have it, if you would like to look through any of it or,
Pass it down.
pass-
Looking for that too. I saw it
Yeah,
enclosed
no,
and I'm flipping back and forth.
No, it
Then I
was
got
in-
to thinking,
there
I
you
bet they didn't scan all that.
no, it's quite lengthy.
Anybody apply for this kind of a educational course? Is that the deal?
They, certainly they're welcome to make applications. It is up to the commission as far as approval based on required.
The sponsor has to get approval according to the rule, and this sponsor has already, I believe it says, has already been approved. Is that what I saw on there? The sponsor had already been approved, the person that's instructing?
He's in,
Oh, okay.
Approved
He's
in
in,
Georgia.
okay, all right, I'm sorry, that's what I saw. Okay, application to become providers. And the rule, and do we have the CE rules? I'd be happy to pass you all down a copy of the continuing education rules.
Commissioner, is that in there?
Oh, do you have them? Okay, it's chapter 0160-3 are the parts. It's up at the top. It says continuing education, and particularly the fourth rule, 0160-3-.04 qualifying programs. Subsection 2 says a sponsor of a continuing education program shall obtain approval from the commission as provided in this chapter. And then subsection 3 says formal programs requiring attendance may only be considered for approval by the commission if it outlines that an outline has to be prepared and preserved. It's at least 2 hours in length. The program is conducted by an instructor, discussion leader, or lecturer qualified in the opinion of the commission by either education or experience or both. That would be your grounds for consideration of the instructor. And D, a record of registration and attendance is maintained and certified by signatures of an authorized representative of the organization sponsoring the program.
What is this guy's background?
It appears that it says on the check sheet, he's been a Georgia auctioneer licensee since September of 2004, and there's a copy of a BS certificate in here. Looks like this individual, according to the printout from Georgia, has been licensed there since, it says '09, I'm sorry, the first page says '04, but I believe the printout, well, I can't.
What's his baccalaureate degree in?
There's a copy of that in your book, Bachelor of Science in
Science of Electrical Engineering.
Technology.
Google topics.
When you read, it appears to be 9/29/09
Yes.
instead of 4.
He has to have been a licensed auctioneer for 5 years or have a back. He did not meet the 5-year, he's just shy of the 5 years.
Licensed auction.
I don't believe. All the documentation, the only thing he provided was from Georgia.
Website op. Search engine.
I
I'm not,
don't know if there's anything wrong with it, I don't know if there's anything great about it either.
I mean, I don't know what advantage it has to our commission or the members, licensees to have another course by somebody from another state that's.
Guys, continuing.
Says they were.
There's a letter.
Other one, 7. Other.
Tab 7 is actually for an auction school, so it's a little bit different. So I mean, that may not affect your decision, but I did want to point that out to you.
They want to do auction school here?
It's an auction school that's located in Ohio, but they want to be approved as an auction school
Oh,
to
okay,
instruct
so
Tennessee.
people
So it's
go-
not continuing
I got you.
education.
So
It's
it-
actually, it falls under a different rule, so
I
it's a
got you.
little bit different. I don't know if you want to move on to that yet.
Wilson, do you want? Continuing education application? It's been moved and seconded that we table the continuing education course application of Antoine Rochette to the next meeting. All those in favor say aye. Aye. So we're gonna table that one. If you would bring that one back up.
Yes, sir. Is there, I did have a moment to research the Tennessee license. I did not find them licensed, but I certainly will include that in the packet for next time. Is there any additional information or information you would like us to request from the applicant, the state of Georgia? If you,
I think the commissioners just wanna think about it.
that's perfectly all right. I just wanted to make sure if there was anything.
Wasn't anything about it that reached out and grabbed.
Okay, perfect.
You need to pull your microphone over a little bit closer, Bobby, so people can hear what you're talking about.
Wasn't anything about
If and we'll be happy to ask.
Next item on the agenda is an application by the Ohio Auction School to become an approved auction school for Tennessee auctioneer applicants, as I understand it. Is that correct?
Yes, sir. They would be offering the 80-hour pre-licensing course.
Mike Brandley is the main instructor or the executive director, I guess.
Director, according to the application. It appears from the information submitted, there would be 7 other instructors. I will draw the commission's attention because this is something that Ms. Whaley and I just discussed on Friday, because this information was just submitted last Thursday afternoon, the 3rd. I believe they were under the impression that they were approved maybe and realized they weren't and submitted this information. So what you have in this divider is all we have, I believe, from this provider. And in researching the rule for approval of auction schools, it is somewhat different than continuing education. It is a separate rule. There's a rule entitled auction schools found in the first chapter of your rules, and we have a copy here if y'all would like for us to hand to it. Or I can give you the rule number if you want to flip to it
Just a
in your
real
book.
number would be helpful.
Sure. It's 0160-01, and it's .10. It's entitled Auction Schools.
There you go.
.10, and it's entitled
Page
Auction
2 of our rules.
Yes, sir. And that is the, those are the qualifications that need to be demonstrated to the commission in order for the auctioneer commission to approve an auction school. When looking through their materials, I'm not sure, just based on my own review, that there's sufficient information here to cover all of these documents.
Under Rule F, it says that they have to provide instruction in public speaking, bid calling, sales management, advertisements, contracts, closing statements, license law, UCC, bulk sales, and firearms.
And all we have as to what they're going to be teaching looks to be like a, I don't even know if I would call it an outline, but it's a breakdown of times each day.
Right.
And according to who teaches them. Another qualification for an auction school is under Part C if they're conducting 80 hours of instruction, including at least 40 hours under the supervision of a licensed auctioneer with at least 5 years of experience. While they included some blurbs about these individuals teaching, I'm not sure, I couldn't make sense of the information that was provided to ensure that at least 40 of those hours, even if they do cover all of the topics specified in the subsection F that the chairman pointed out, I'm not positive that we have adequate documentation.
Why don't we do this? Why don't we postpone this application to the next meeting and give you time to really kind of suss out what they've got, what they don't have, and let provide you with additional detail.
Yes, sir. That was actually
Perfect.
to the commission.
We did want to present it to you all because we had it before this
That's
meeting,
okay.
but in our review of it, we had
Unless,
some concerns.
unless one of the other commissioners has a problem with that.
I mean, unless you all see something that I don't, I
No,
just want to be sure
I
that.
think that's a good idea, and it's just kinda like, going back to that last one too, if there's something, and maybe their resume a little bit is, you know, the guy from Georgia, rather than, I've
Resume?
been an auctioneer for 5 years.
I think that would be more
That's
helpful to
great,
you
know,
all
but
when
just-
looking at it.
Just have a little something extra, you know.
And all we have on that gentleman was his licensing printout from Georgia.
Right.
So,
And that would make me a little more comfortable,
So
I
a
think,
resume.
if I had a little more.
More information is always better when
Right,
looking at these.
right.
I mean, at least a couple of these people I have come across, you know.
And I'm not trying to say we doubt their qualifications in any way. I'm just saying that under the rule, I'm not sure that we have the documentation, not that it's not
I think
there.
you're right, yeah.
Okay. I think that takes care of those two items, unless you'll have any questions from us.
well, I
You
do-
got a legislative update?
I think we do need a motion.
Okay.
I move that we,
Table
table
that.
this until y'all can gather a little more information from them.
Second. Second by Ronnie, all in favor say aye. Aye. So that motion passes.
As far as a legislative update, there was not any legislation that directly affected the auctioneers this year. So
Right, good deal.
hopefully wrapping session in the next.
Any other new business to come before the commission today?
I do think at the next meeting, education provider and information, Julie and I want to put together some information that
You need to bring that mic closer to you.
it
so
keeps
that-
cutting out on me.
Yeah,
Bring back some information related to the education providers and the auction schools, just to make sure we're preparing the documents for the commission, as well as meeting the requirements that are in the laws and the statutes. So we will include that.
okay, good.
I think it might be helpful for you all to maybe have a little bit better cover sheet for an auction school because it actually has the same qualifications as a continuing education course. And when going through this, we were thinking it's totally different. I think it could be laid out better for you all.
A little more intensive.
Right, and, you know, the commission's desire to see copies of the licenses and those types of things. We
And
want to
quite
make
honestly,
sure.
I think we
we
need
present.
to have, from our standpoint, some compelling reason to act on it. Rather than just them trying to get our approval and us saying yes. I mean, I'm looking for some compelling reason that adds benefit to our state licensed leads. If they can provide that, that would be helpful.
I think that might be something to look at the application that they complete, that we reach out to them for them to provide that information to us.
Right.
So we're gonna look at the two kind of as a whole in the
Have you changed?
education. Certainly, yes, absolutely, and bring those back before the commission for approval, and
Okay.
I think it's been a number of years since that's been looked at, so time and cases always bring things to the surface, so we definitely wanna.
Any other new business?
I will remind everyone, we are scheduled for a formal hearing at the next, scheduled meeting in May.
Right.
Now, that is subject to a
Much stuff.
continuance. The
But
person
it has
could-
been filed,
it
is
has
my
been filed, yes.
understanding.
So the person could request a continuance, and the morning of, we tell you we're not having it. But we just want to make
And they're
everyone,
done that.
we
And
want to make everyone
I
aware.
want to bring up Gary Cunningham's situation in that, you know, he's been kind of on a month-to-month basis since August. And I think as a commission, we need to have either him be reappointed or find whoever his replacement is going to be.
Yes, sir.
I don't know who we talked to about that.
I-
I don't think we got a whole lot to say
Well,
about
we
that.
may not, but I'm just saying,
And
I just want to put it on the record.
Yes, sir.
I think that's a little bit reason why he's missed a few
Yeah,
meetings.
it's really not fair to him.
It's not fair to Gary, and it's not fair to this commission, because we run the risk of not having a quorum when we've got 5 members and one's going to be consistently absent.
Absolutely. I do inquire on a regular basis to that, not a vacancy, but to that seat. And right a few days before the meeting, I inquired, and there was no update on a replacement. So
I'm just-
I will continue.
I just
and
want to be
I
on the
will- I
record
will-
that we're concerned about it.
I will express your concern to the office that handles that.
Okay.
And
All right, good deal. Do I hear a motion that we adjourn?
I so moved.
Been moved and seconded. All in favor, say aye. Aye. We are now adjourned.
I think we ought to get that.